Advocate Simelane was criticized because of the allegation that he was interfering in the role of the NPA. This criticism was contrary to the judgment in the matter of National Director of Public Prosecutions versus Zuma on the 12th of January 2009 in paragraphs 30 to 34, that, amongst others, it was stated, the Constitution on the one hand vests prosecutorial responsibility in the NPA, while on the other, it provides that the minister must exercise final responsibility over it. These provisions may appear to conflict, but they are not incompatible. The minister is entitled to be informed in respect of all prosecutions initiated or to be initiated which might arouse public interest or involve important aspects of legal or prosecutorial authority. Advocate Simelane was criticized that he had provided the former Minister of Justice with incorrect advice where he had drafted a letter dated 18 September 2007. The former minister authorized and approved the contents of the letter by appending her signature thereto. The Ginola inquiry should have called the minister as a witness and should have questioned her on all these issues. Let me add that during WAPA 2004, the PSC, the Public Service Commission, conducted an investigation onto allegations pertaining to mismanagement, corruption, and procurement irregularities in the NPA. It submitted a report to former Minister Mabanja as the executive authority who exercises final responsibility over the NPA. The accounting officer, the Director General, was advised by the PSC to take action against the CEO and others. To me, this shows clearly that the PSC considers the Director General as the accounting officer with the responsibility to implement the public service regulations against members of the National Prosecuting Authority. This procedure constitutes an acknowledgement of the role which the Director General plays in respect of the NPA. The Ginola inquiry, in investigating the irretrievable breaking down in the relationship between the minister and the NDPP, should have called the minister to give evidence, as she was allegedly a party to the relationship which had allegedly broken down. And having considered all relevant factors, I am satisfied that the PSC's recommendations do not justify conducting disciplinary hearing against Advocate Simelane for the following reasons. Firstly, the attack on the credibility of Advocate Simelane by the Ginola inquiry was without foundation, as the letter was already in the possession of the Ginola inquiry, and therefore there is no foundation in the allegation that Simelane had misled the Ginola inquiry because it did not disclose the letter. Secondly, as far as the allegation is concerned that Advocate Simelane had failed to disclose the legal advice that he had obtained, there is no reason to disbelieve him when he later corrected himself. And furthermore, the provisions of Section 36 of the NPA Act completely corroborate the evidence of Advocate Simelane that the NPA was accountable to him as the accounting officer. There was no merit in any of the findings by the PSC recommending a disciplinary inquiry against Advocate Simelane. I found the submission persuasive, and consequently I have accepted it. I have therefore in my disposal the recommendations by the PSC and the submissions by the advocates and I have no hesitation whatsoever to accept the opinion of senior counsel and advocate. I'm satisfied that the decision not to subject Advocate Simelane to a disciplinary hearing is correct, as there is no reliable evidence of misconduct which justifies a disciplinary inquiry. Going forward, I want to state here that I'm satisfied that Advocate Simelane is in fact a fit and proper person to provide leadership to the National Prosecuting Authority. Further, I'm confident that as a member responsible for the administration of justice, I will continue to have a healthy, professional relationship with the National Prosecuting Authority, founded on the provisions of our great Constitution and the law. There is no doubt in my mind that the new National Director of Public Prosecutions will ensure that the NPA continues to discharge its prosecutorial mandate and independence within the Constitution, which in terms of the Constitution 1794 provides that the prosecuting authority exercises its functions without fear, favor, or prejudice.
Our Constitution requires us to, quote, honor those who suffered for justice and freedom in our country, respect those who have worked to build and develop our country, and believe that South Africa belongs to those who live in it, united in our diversity, close quote. The NDPP must ensure that the prosecuting authority exercises its functions without fear, favor, or prejudice. Today, I'm honored and humbled to have been considered by the President of the Republic of South Africa, Mr. Jacob Zuma, to be the National Director of Public Prosecutions. Therefore, I have accepted the appointment and pledged to serve the people of this country with respect, honor, and without fear, favor, or prejudice. I think that is what is expected of the National Director of Public Prosecutions and the National Prosecuting Authority.